Hi guys, welcome to Manoeuvre MH Law CET video for 3 years and 5 years. Okay, and my today's topic is about the Partnership Act and the Limited Liability Partnership. What is Limited Liability Partnership? Why it has been introduced, as there was already Partnership Act. So basically, to fulfill the shortcomings of Partnership Act, LLP, that is Limited Liability Partnership, was introduced. Now shortcomings like what? Shortcomings like maximum numbers of partners or liabilities of partners, foreigners that can be admitted as partners, etc. There are so many such limitations or shortcomings in the Partnership Act which prevented to people to enter into a partnership firm. So now we will look into some of the differences to understand the topic in a better way. Now over here we see there are 4 columns. First is the serial number, and the base is the topic in which there is a difference. Then the LLP, that is the Limited Liability Partnership, and the partnership firm. Okay, now we'll see the basic difference between the two, so you will come to know the topic better. So any question posed in your examination can be answered well. Now this LLP is governed by the Limited Liability Partnership Act 2000, okay, and partnership firms are governed by the Indian Partnership Act 1932. Now whether it is a separate legal entity or not, LLP is a separate legal entity, okay, from its members. This is the core reason why LLP has been formed, because as we see in partnership, it is a group of persons with no separate legal entity. Okay, it is not a legal entity. The partners and firm both are one and the same person, but over here LLP, it is a separate legal entity, so your liability are also limited. Now we see over here the liability in partnership. So in LLP, liability of each partner is limited to the extent to agreed contribution except in case of willful fraud. So if there is a fraud played by a partner, then of course that partner is liable for it. But otherwise your contribution, your liability is limited only up to your contribution. Now liability of each partner is unlimited. So you are responsible for the acts of others also. It can be extended up to the personal assets of the partners. So if at all the firm does not do well, then you have to pay your debts from your personal properties also. But in LLP, the case is not that. Your liability is only up to the agreed contribution. Mutual agency. In LLP, each partner can bind the LLP by his own acts and not the acts of the others partners. Now over here in partnership, each partner can bind the firm as well as other partners by his own acts. So you are responsible even for the acts of others, whereas in LLP you are not responsible for the act of the other partners. So it gives you a higher scope to get into any of the partnership deeds. Okay, now over here the number, this was one of the other reason why LLP was formed, numbers and numbers of partners and requirements. Now over here in LLP, minimum 2 numbers are required and there is no limit for the maximum numbers of partners. But in partnership firm, it restricted only to 20 members. Minimum 2 is there, which is same in LLP also, and in maximum partners has to be only 20. No minor can be a partner and minor can be a partner. So this is also another issue over here. Now foreign partnership. Foreign nationals can become a partner in LLP. So this became a big gateway for the foreigners to invest here. Okay, but over here in partnership, foreign nationals cannot be admitted as a partner in the partnership firm. Okay, so over here this is one of the major difference between the two. So we see that the liability is limited in LLPs. The maximum numbers of partners can be there is no limit to it. Then foreigners are allowed. So LLP gives you a wider scope, a clear scope to get into this type of partnership. Minors can be admitted to cannot be admitted to the benefits of LLPs. Okay, in LLP minors are not allowed to be admitted, but in partnership minors can be admitted only to the benefits with the prior consent of the existing partners. So with the introduction of LLP, the foreign investors flew in and things became quite simple because you are not liable for the acts of others. Your liability is only limited to the agreed contribution. Okay, so this was the concept why LLP was in requirement over there. Now, so guys, for more such explanations, if you are Mumbai based, then you can join our classroom programs, and if you are not Mumbai based, then you can join our online programs. Now, over here, we will study some questions which are asked in previous years, so it will give you a light what types of questions come from Partnership Act and LLPs. Now, we see the first question. A partner may make an agreement with his partner that on ceasing, the season is to finish the partnership firm, to end, basically to end a partner, he will not carry on any business similar to that of the firm within a specified period or within a specified local limits. Anything contained in any other agreement shall be valid if the restrictions are reasonable in law and for firm being in post. Now over here we see factual situation is A, B and C are partners carrying on the business of manufacturing and selling stitched garments in a town Z under the name ABC will be a brand name from the firm. On dissolution of the firm, all partners A, B and C are entered into an agreement not to carry on the business of manufacturing and selling garments for 10 years and none of them should use the brand name ABC forever, because if any of one uses, then they can earn on the goodwill. Okay, they can earn on the goodwill which they have to share. So it was decided for that none of the partners A, B or C can use the brand name ABC. Now we see what are the options given. Here, agreement entered into by the partner is void, or they cannot define the time limit of restriction, or the restraint put them by is valid, or a restraint cannot be perpetual. So over here, is the agreement entered by the partners is void? No, because principle is stating that there can be any type of agreement that the seizing partner will not carry business or within a specified period and within specified limit. So it falls into the principle. So the agreement is not void for this matter. So this option is not workable. They cannot define the time limit of restriction. Of course they can define the time limit, or say within a specified period or within specified local limits. They can definitely do this. So this also option is not feasible. The restraint put by them is valid. This is the perfectly okay answer. The restraint put them by is absolutely valid. None of them is allowed to carry on the business or use the firm name for next 10 years. And a restraint cannot be perpetual. In LLPs, this is also not valid. So over here the answer is C. We go to the next type of question. Over here the principle says it is about the application of the property of the firm. It means all the assets of the firm which is there in the partnership firm, how you can use it. So the principle explains us to it clearly that subject to contract between the partners, the property of the firm shall be held and used by partners exclusively. Please take a note of this. Exclusively for the purposes of the business. You cannot use it for your personal use. You cannot use it for any of your other businesses. You have to use it for the purpose of the business of the firm. Okay, that is the thing mentioned in the Partnership Act. So section 15 of the Indian Partnership Act says that which of the four options is workable. Over here we'll check it out. The property of the firm can be used by the partners only. Okay, yes, this somewhere satisfies the answer, but we see over here what it is, the next options. The property of the firm can be used only for personal use of the partners. So this is not at all applicable because we have to use exclusively for the firm. The property of the firm shall be held and used by the partners exclusively for the purposes of the business. Okay, so over here this is an absolutely suitable answer because the first option only satisfies the half part of it, but over here C is a better, which we can applicable to the principle. Both B and C, so B is not correct, so C. So over here, so D is also not required over here. It is not a correct option. So over here C is the perfect answer. So answer of this question is also C. We go to the next question. Now this is based on LLP, okay? I have given you a big hint over here. An organization running a business has the following attributes, okay? The assets belong to organization. Of course, this goes without saying that the assets belong to organization. It can create a floating charge over its assets, okay? Change in membership does not end or alter its existence. So this cannot be partnership, because in partnership, if you change the membership, the partnership comes to end. And members cannot transfer their interest to others. So this is definitely not a partnership. What type of organization is it? The first option is a private limited company, a limited liability partnership, a general partnership, or a private limited partnership. So the option over here is A. It is a limited liability partnership. So these types of questions, they frame for your MCQs, for your MH Law CET 3 years and 5 years paper. So take a note of it, and I hope this video is helpful to you. So guys, if you want to join our online programs, and if you want to join our classroom programs, then you can call for the Borivali centers, you can call on this number, and for the DADAR center, you can call on this number. If you want more information on these topics, then you can hit the subscribe button. If you like the video, please click the like button, and do share this video with your friends and relatives on Facebook and WhatsApp so that even they can prepare better for their exams. Okay, all the best, and please farewell.